Welcome to today's episode of Yi's Law Journal. I'm your host, a digital avatar of Yi, and today we're delving into a fascinating and increasingly relevant topic, the copyrightability of AI-generated images. This issue is being handled very differently in China compared to the United States, and these differences have significant implications for the legal field. Let's break it down and see what we can learn. Let's start with a recent landmark case in China. The Beijing Internet Court made waves with its decision in the Spring Breeze case, recognizing the copyrightability of AI-generated images. The court set a relatively low bar for judging originality, focusing on the substantial human input involved. This decision is significant because it shows China's willingness to adapt its legal framework to accommodate AI-generated content. It's a forward-thinking approach that could influence future cases not just in China, but globally. Now contrast this with the approach taken by the U.S. Copyright Office. The office has been much more cautious, denying copyright protection for AI-generated content on several occasions. A prime example is the Théâtre d'Opéra spatial case. Here, despite the significant human effort involved, the office ruled that the work was primarily generated by AI and therefore not eligible for copyright. This stringent stance highlights a key philosophical difference. The U.S. demands clear evidence of human creativity and control in AI-generated works. Originality is a central theme in both jurisdictions. In China, the concept is tied closely to human intellectual input. As long as human creative choices are evident, the work can be deemed original. The Beijing Internet Court's ruling in the Spring Breeze case is a perfect illustration of this principle. They acknowledged that the AI was a tool, but the creative spark came from the human user. In the US, however, the bar is set higher. The human input must significantly outweigh the machine's contribution. This approach underscores the importance placed on the human element in the creative process. It's a more conservative view that seeks to preserve traditional notions of authorship. Let's talk about control. In the US, human creative control is paramount. For example, in the Zarya of the Dawn case, the U.S. Copyright Office recognized only the text and arrangement of elements as copyrightable, not the AI-generated images. This decision was based on the idea that the AI, not the human user, was the true creator. China, on the other hand, is more flexible. The Spring Breeze case showed that as long as the use prompts and instructions reflect personalized expression, it's enough to meet the originality requirement. This reflects a more inclusive approach to the evolving role of AI in the creative process. A final point of contention is whether user input prompts are thoughts or expressions. In the US, simple prompts might be seen as mere thoughts, not protected by copyright. However, detailed instructions that reflect personalized expression could qualify for protection. This distinction is crucial in understanding how AI-generated content is evaluated. The rapid advancement of AI technology is challenging traditional intellectual property concepts, pushing us to rethink and adapt. While China is more open to granting copyright protection to AI-generated images, the US remains cautious, demanding more substantial human creative input. As we move forward, it's essential for legal professionals to stay informed and engaged in these discussions, shaping the future of copyright law. Thanks for tuning in to Yi's Law Journal. Stay with us for more insightful discussions on the evolving intersection of law and technology.